someone from Metro-Dade or Hialeah that has experience in cell phone extractions and examination to make sure that the exhibit is not improperly handled or tampered with. We've done this before. I actually have an order in that regard. So you'll provide a name if you want to do further examination of the phone. You'll provide the name of the expert, and that expert will be working under some guidelines to make sure that the integrity of the evidence is preserved. So you'll let me know what you want to do with that. I think I'm probably going to order up another status conference like this within the next 3 weeks to see where you are. And we'll see how our trial schedule opened up. But other than the phones, as far as the physical inspection, one, you guys are going to coordinate and set up a physical inspection. Any type of electronic evidence, you're going to, or scientific examination, that'll be by subsequent motion. Okay. Anything else y'all would like to? That's a lot of stuff we've done today, and thank you. Yep. Is there anything else y'all would like to do today?
The only thing I want to mention, Your Honor, because I didn't want to interrupt and we moved on, is just to going back really quickly to your thoughts on a potential future trial date.
Say that again? Potential what?
Future trial date, Your Honor.
Oh, yeah, okay.
Is that, as I mentioned, a number of depositions that had been scheduled were canceled, and we're in the process of rescheduling, and we have sent out some dates at the beginning of November. Mm-hmm. Then also that, as for the state, we're also waiting to see if there will be any affirmative defenses or any experts necessary, and we do not have any. There has been nothing of that kind done yet, so I just wanted to mention that may take some time.
Well, if you guys are thinking of depositions in November, you're going to be way short, because if we're envisioning a December 2 trial date, you're going to be way short. My suggestion is y'all need to be figuring out a week or two where you can get everybody that you need into the room. And Ms. Riello, I suggest getting the most important witnesses at the top of your list. If you guys need my assistance, and I have offered this before, I will set aside 2 weeks where every witness in this case shows up here, and you depose until you're done. And they'll be under my summons. So I'm going to ask you if you guys can cooperate to expedite your discovery schedule here. As I said, it's an extraordinary case, and we owe it to Derek to get this case finished as quickly as possible. I'm sure you feel that way as well, Ms. Riella.
Thank you, sir.
All right, so I'm going to ask Mr. Frankel to prepare this order with regard to 2 minor matters that we've done. First off is just to recap, the Facebook printouts will be available at the time of the deposition of the detective, and any further disclosure of them will be after motion. I've ordered all text messages with regard to Losigi and Ramos. And I think we addressed also Losigi and Verdesia. The state's going to take a look to see if there's anything else there. Or I think I may have left that just to see what you got after a deposition. Okay. All right. So I'm not entering a huge order here, but again, I'm envisioning seeing you guys again in about 3 weeks. I'll give you some notice on that. It seems that when I set anything, even without extensive notice, we get a nice crowd. And as to all, is there any other items of business that any party wants to address at this time? Okay. Again, thank you very, very much for all the hard work that everybody's putting in here. And for those of you who are on our screen, thank you for joining us today. And we look forward to having you observe future proceedings in this matter. If there's no objection, I'm going to go ahead and close Division 13 until 9 o'clock tomorrow morning.
Okay, thank you, sir. Have a good day.
Thank you, Judge. Have a great day. Thanks. For sure. I'd like to see this done as quickly as possible.
Thank you, Your Honor. I'll prepare an order today.
If you would pass it past Ms. Jones Cummings, so at least she has some notice. I don't know what standing she has to object to anything there, but I'll want to take a look at it. And if I need to speak with Ms. Langer, I don't know if I'll cross that bridge when we get to it. Okay, I want to move to the discovery issues now. I have reviewed, and I'm looking at side by side, two documents. One of them is the defense response to the state of Florida's court-ordered interim discovery report. Oh, and I'm looking at the state's interim discovery report at the same time. So on some of these things, you guys have reached consensus. On others, not so. So the first thing I'll ask is, the first area of disagreement I have is when you speak to the Facebook printouts. On the defense pleading, that appears on page 2, paragraph 1. Everybody on board with that?
Yes, sir.
On the state's pleading, it is paragraph 5. The state objects to the provision of the Facebook printouts. I have some question about this. When you say Facebook printouts, what is that? Ms. Morales or Mr. Borst?
Good afternoon again, Your Honor. So I tried to explain in five, but essentially so if we go back to the early on investigation, Your Honor may recall that before the defendant called 911, he called a friend that was by a name that wasn't the person's actual name, and had, a conversation of some time after the killing before he called 911. So when the detectives were investigating, trying to figure out who this person was that had the conversation with the defendant in between those two things, the defendant in his statement to police gave some information, and then when access to his phone became available, they were able to locate a phone number. That phone number, they then did subpoenas to the phone company to try and get subscriber information to who that belonged to. It's not a local number, it's in another state. And then through their investigation, trying to identify who this person was, when they were able to see in the chat on the defendant's phone, that other minor sent a picture of himself to the defendant. So when they were looking up the adult who pays the bill, right, for that phone, they looked on Facebook and just input the person's name. So in the way that any person has their normal Facebook page and it shows like a picture of themselves and their name, that's what I'm talking about. So when they looked at that person's, that's an adult, they were able to see friends of that person, which included the minor child. They were able to figure out that minor child was the same person the defendant spoke to, because the picture of the Facebook profile of that child is the same person, essentially, that was in communication with the defendant. So, long story short, just as a part of their file, they printed out the profile page of the adult who's not a party to the case, who pays the phone bill for the child that the defendant was speaking with, the child's Facebook profile picture, and the child's mother profile printout as well, who's also not a party to it. They then used that information, which on it had a county in the other state, and then the detectives went to that state and used local law enforcement assistance to locate the home, essentially, and that's how they ended up with the interview of that child. That interview was recorded. It's been previously turned over in discovery, as well as all of this explanation of how it got there. So that's essentially what it is. I have them, and I put in the email when I sent it over that if Your Honor wanted to do an in-camera review just to see exactly what it was, in case my explanation was not giving a full picture, that I was happy to walk over, which I still can do if Your Honor wants to see the camera, but that's essentially what it is. It's 3 different people's Facebook profile pages that the detectives just printed out.
So I guess the questions I need to ask are, Ms. Riello, why is it discoverable under 3.220?
Well, Your Honor, I think that, well, I imagine that part of the reason why Ms. Morales has all of this information regarding the steps taken throughout the investigation is because she's spoken to the detectives. I assure you, I've read all of the discovery, and nowhere in there does it lead me step by step to what Ms. Morales just said. It is discoverable because, according to Rule 3.220, subsection B1B, a statement, which is what the state is citing as an objection to why this is not discoverable, is specifically intended to include all police and investigative reports of any kind prepared for or in connection with the case. I believe that we have the right, in order to explore all viable theories of defense, to be taken through those exact steps that the investigation took lead detective Elosegui through. All I know about these printouts, and that's why I also call them printouts, is because on page 7, as I stated in my motion, of the detective's report, which I have read several times, he himself points the reader to refer to the printouts.
Okay, I'm going to stop you right there. Ms. Morales, obviously your detective has it in his case file. I'm assuming he has these printouts in his case file.
I'm sure he does, Judge, because he gave them to me.
There you go. I'll tell you what, Ms. Riello, when you take his deposition, you can ask him to show them to you then. Whether you need copies of them after that, we'll litigate that later. Does that work for everybody? All right, I'm going to also ask you to note this as one of the things that I expect to see in an order that one of you will prepare for me, or maybe Mr. Frankel will, when we're done.
Yes.
So, with regard, yes, ma'am.
I'm sorry, Judge, I don't want to interrupt.
Mm-hmm.
When the video recorded statement of that minor child was turned over, his face was blurred. If we are the video recorded statement of that minor child was turned over, his face was blurred. If we are turning over the one of the minor child, may we blur his face?
Well, you're not turning it over yet, ma'am.
All right, understood. But if we get there, may we blur?
Yeah, if we will cross that bridge when we get to it. At this point, the defense will have an opportunity to get a look at it during the deposition, and if there's need for them to have copies of it, because we're talking about identities of juveniles and things that I believe are appropriate under the protective order provisions of Rule 3.220. But if it becomes an issue after you've seen them during depo, we'll work on that then. All right. As to, I think the next area that the defense raises, text messages between Detective Elosegui and Mr. Ramos. Now that goes to paragraph 6D of the original, of the third motion to compel, and it refers over to paragraph 9 in the state's response. So paragraph 2 in the defense pleading, paragraph 9 in the state pleading. Text messages between Elosegui and Ramos. The state indicates this should be denied as they turned over the text messages between them on June 24 of this year, and they are not aware of any additional messages. The defense, on the other hand, asks me to order all additional text messages after October 19, 2023. So, are there any text messages between the detective and Mr. Ramos that have not been turned over to the defense? Ms. Morales?
I don't believe so. Upon receiving this again, reached out to Detective Elosegui and asked, and was advised that the only message was what had been turned over, which was when Mr. Ramos sent a couple of pictures, I guess, from a baby monitor, and that was it. So I know both of them are subject to deposition. To the best of my knowledge, that's all that exists at this time.
And excuse my ignorance in this sense, but you guys have access to all the discovery, and you've been working super hard. I only get what's brought before me. Okay?
Right.
I'm assuming that Mr. Ramos is the stepfather?
Yes, he's the father of, yes, he's the stepfather.
And the father of the infant that was in the same room at the time of Miss Garcia's death. Okay,
yes.
Good. Let me say this, because I'm running into this issue in other cases. I'm going to ask that you make sure that Detective Losagui understands that his communications by text with Mr. Ramos, who I'm sure is some type of witness for you in this case, that those text messages are discoverable. They are statements of witnesses, okay? They are not to be deleted. They are not to be destroyed. And any text messages between the detective and a witness are to be turned over under Rule 3.220.
I will let him know, Judge.
Ms. Riello, you will have an opportunity to depose, obviously, these two witnesses. And if there are any text messages that you learn about between them, you will inform the court. We'll order them produced. Okay?
Your Honor, and just to make the record even more clear,
Sure.
I don't know, obviously I don't know, but I have, as I've said, I've reviewed the discovery. I've done so thoroughly, and it appears to me with certainty, based on what has been provided, that at the very least, on November 27th, 2023, there were additional messages on the same thread that the state previously provided. So I am asking, and I could, you know what, I could go ahead and file another motion and I can attach that as an exhibit.
Let's do that. Okay. And in fact, perhaps if you guys were to pick up the phone and speak with each other, Ms. Morales, you might call your detective and identify those specific dates and see what you got.
Yes, Judge, I'd be happy to. From what I know, that's all there was, but I'm happy to tell him to look specifically back to that date.
You're under an obligation to turn him over. And
Yes,
if you don't see him in the next week or two, Ms. Riello, you'll let me know by way of a motion. But the state is on notice that they're required to turn over the text messages. You've put them on notice that they may be missing some. And I'm going to, let's make the second thing we're putting in this order. All text messages between Detective Losagui and Mr. Ramos shall be produced. All right. Paragraph 3 in the defense pleading at page 4 corresponds to paragraph 10 in the state's pleading. That deals with Detective Losagui and Mr. Verdecia, who, what I'm learning about from your pleadings, cleaned up the murder scene after it had been released by the police. The state indicates that they or seem to say there are no text messages prior to today, and that they have sent a video that Mr. Verdecia took while he was cleaning the bloody murder scene after it had been released. Is there a reason to believe, Ms. Riello, that there's something else out there?
Well, I think before we even get there,
Yes, ma'am.
with this particular item, I had an issue because it's kind of wacky or illogical to conclude that I would know of text messages on the 17th of July that were not exchanged until the 6th of August. So again, I'll repeat, I don't know what I don't know, but reviewing the discovery that has been provided so far, I do believe that there are additional text messages between Detective Losagui and Luis Verdecia. Now, what I'm asking for is not only those additional text messages, but I'm also asking for a better exhibit than the one that was provided, because the one that was provided, although it says that it was exchanged on the 6th of August, there's no timestamp, there's no date stamp, so there's no way for us to see exactly when that was exchanged between Detective Losagui and Verdecia.
Okay. After you take their depots, if you're still unable to figure that out, then we'll go ahead and do that. But right now, because we're one of only 4 states in the country that allow pretrial statements from witnesses, I'm going to ask the parties to avail themselves of